Greetings and welcome to Unit 5, the Court System of Texas. In this lecture, we will discuss the different types of law, the differing sources of law, the different types of jurisdiction, and we're going to describe the selection process and the qualifications of Texas judges. Like usual, we have a lot of ground to cover, so let's just dive right into this. So there are two types of law that we need to become familiar with. We have civil law and we have criminal law. We'll talk about criminal law in just a moment, but let's focus right now on civil. Civil law deals with disputes usually between private individuals over relationships, obligations, and responsibility. So some examples, family law and probate law, right? So family law, so we're talking about divorce, child custody, protective orders, etc. And probate law, we may actually be a little less familiar with probate law compared to family, but probate law deals with the estates of individuals. A prime example is, what do we do with the the goods, the materials, the stuff that we own when we pass away. That's an example of probate law. So the burden of proof in civil cases is actually much lower than that of criminal cases. And like I said, we'll talk about criminal law in just a moment, but the burden of proof here is significantly lower. That is to say that the burden of proof is the preponderance of the evidence, which is, again, a lower standard compared to beyond a reasonable doubt. So the level here, and this is what we really need to get from this, is that it's lower, it's different. Okay, that is to say that the evidence doesn't have to be as robust as we will see here in just a moment with criminal law. Okay. So we have relief or remedy that could be issued here in civil cases. So let's hypothetically say we have individual A, okay, that is accusing an organization or an individual of defamation. That is to say that this individual that belongs to this organization knew what they were saying was false, and they said it anyways. They put it out there, and that information hurt the reputation of individual A. Okay, and let's say that the court ruled in favor. That is to say that the court found that this organization is actually guilty of defamation. Well, then the court would issue a relief or a remedy, and that is to say that it could be a monetary relief. Here's that the organization has to pay a large sum of money to this individual for that defamation, for the harm that was done, or it could be a cease and desist. Right, so we're talking about a relief or a remedy to the situation, to this dispute. Okay, and let's dive into criminal law. Criminal law, it regulates the conduct of individuals, defines crimes, and specifies punishments for criminal acts. Okay. Another way that we could potentially distinguish criminal law between civil law that might make this a little bit easier, okay, for us to keep this in our heads. In short, okay, anything that is not criminal law is civil law. Okay, so but let's dive back into this. So criminal law, right, regulates the conduct of individuals, defines crimes, and specifies punishments for criminal acts. So what are some examples, you may ask? Well, it's a wide range from misdemeanors all the way up to felonies. Misdemeanors such as a traffic ticket, right? This is a Class C misdemeanor. Traffic ticket could be speeding, right? Or your vehicle registration is out of date. And we could go all the way up to felony charges, which can deal with embezzlement. It deals with fraud. It deals with murder, right? So we have differing degrees, differing levels, and we'll talk more about those degrees and levels later. But just note right now that that criminal law deals with minor violations of the law to very serious violations of the law. Okay. And the burden of proof here in criminal cases is actually much higher than we saw in civil law, in civil cases. It's no longer the burden of proof is no longer the preponderance of the evidence. Now it's beyond a reasonable doubt, right? So hypothetically speaking, let's say we have an individual that is guilty of speeding, excessively speeding, right? Well, the law enforcement must have proof beyond a reasonable doubt that it was actually that individual that was doing all that speeding, that was excessively speeding, right? So the burden of proof is much, much higher. It's and it makes sense for that, right? Because we're talking about potential consequences here of being a fine, a large fine, to imprisonment, or in some serious cases, maybe a mixture of both, right? So, for misdemeanors, specifically referring to traffic tickets, right, we're often looking at, right, a fine. But as charges go up, as we go up these levels of criminality, right, the punishment becomes more severe. We could be looking at a heavier fine, or we could be looking at imprisonment, or, like I said, both. Right? So now let's move on to the sources of law. Okay, so we have a few sources that we need to become familiar with, right? So let's talk about constitutional law, and this one we actually maybe a little bit more familiar with compared to the others, and we'll talk about those in just a moment. But constitutional law, all right, this is the body of law that defines the role, the powers, and the structure of different identities within a state. Now, this could be, at the state level with the state constitution, or this could be at the federal level with the U.S. Constitution. Right? But we're talking about a constitution that clearly lays out these, what I've referred to in the past as these sandboxes, right? That the Texas legislature has this sandbox for which they can fully operate in, but they cannot go outside of those confounds that the Constitution of Texas establishes. Likewise, the governor has a sandbox for which they can operate within, but they cannot go beyond that in the judiciary, etc. Right? Well, the Constitution also establishes basic rights of citizens. Now, I know I've said this already, but it's worth repeating one more time. And that is to say that civil liberties do not derive from the Constitution, of any Constitution. They are derivative of the simple fact that you exist, if this makes sense. In other words, that civil liberties, it's not like the government wrote down an exhaustive list of all of our civil liberties and go, hey, citizens, here you go. Be thankful that we did this. No. Civil liberties is a restraint applied to the government to ensure that it doesn't intrude on our civil liberties. Our civil liberties, it's really hard to define all of them because it's nearly impossible, to be frank. Now, we are accustomed to a kind of a comprehensive list. I'm referring to the Bill of Rights, but that's not comprehensive. Okay, so our civil liberties, where do they come from? They come from the simple fact that you exist. They do not come from a government document of any kind. But civil liberties are protected by the Constitution. That is to say, they are restraints that are applied to the government in regarding its relationship with you and I. I'm digressing. Let's move on. Okay, so the constitutional law also establishes the relationship between the central government the state, and the entities under the state. That includes municipalities and county governments, right? So we've hinted at this. We've already talked a little bit about this already when we talked about federalism. But just kind of recall here that the Constitution lays this out, right? We have federalism, which allows the state governments to be able to operate with its own autonomy, right? I mean, yes, we have the National Supremacy Clause that guarantees that when there's a conflict between state and federal law, that yes, federal law will always win, will always supersede. This was baked into the U.S. Constitution. The framers of the U.S. Constitution provided us that provision within the Constitution. So that's deeply rooted now. But still, yet the states have the autonomy to be able to operate, as long as there's no violation of federal law, whether it's established by constitutional law or by statute. More on statute in just a moment. But the idea here is that states, we can create counties, we can create these other local governments and special districts and etc. State governments have that autonomy. Now, the autonomy that local governments have, that's different. We are at the subject. All local forms of government, we are at the subject of the state. That is to say that all authority that we have and that we can use is directly derived, explicitly from the state, whether it's the Constitution or or by statute. Again, more on statutes in just a second. But the idea here is that local governments, they are subjected to directly to the state, and the authority that local governments, municipalities, counties, they have is directly, explicitly granted to them, and it can be modified, it can be changed, it can be they could be given more than what we have seen in the past. Local governments have been given a lot of authority to be able to operate, and we've seen state take away some of that authority. Right, so the relationship is different than between the federal government, the central government, and the state government, compared to the state government and the local government. One way, just a quick analogy that I like to use to help us to distinguish this, okay, is kind of a spouse-child relationship. And here's what I mean. So let's take, I'll use myself, my wife and I, for example. When we first got married, okay, or should I say right before we got married, we had a conversation, and I cannot remember who started it, but we had this conversation about responsibilities. Who's going to do what, right? In short, I'll make this long story short, I can't remember, again, who started, but she said, I never want to do dishes. I said, no problem. I will do the dishes. I don't mind. She said, well, okay, well, if you do the dishes, then I'll do all the cooking. I was like, sounds great. In other words, we each have autonomy. We each have our own responsibilities. And yet for a child, to use the analogy of a child here in this case, the child really doesn't have any authority at all unless the parent grants that to them, right? That's the situation for the states, right? The parent has no, the child really doesn't have, when I say a child, I do mean a child, not like an 18-year-old, but I'm talking more like an 8-year-old, right? 5-year-old, 8-year-old. They really don't have the authority to tell the parent, i.e. the state, what to do. Does this make sense? So that's what we're looking at. State governments, federal governments have the autonomy to operate and be able to operate, and then local governments, the only authority they have is directly derived from the state government. I am digressing. Let's move on. So we have now statutory. I mentioned it just a moment ago. What are statutes, right? Or what statutory laws? Statutory laws statutory law are simply laws passed by the legislature. That's it. We're looking at laws passed by the legislature. Now, you may recall that we do have two levels of government, right? We have the state government. Oh, okay, technically we have three when we talk about county governments, but bear with me. We have two levels of government. We have the federal level and we have the state level. We've already kind of mentioned this already, but just a quick recap that we have a legislature here at the state level and we have a legislature at the national level. At the national level, we have the U.S. Congress. At the state level, we have the Texas legislature. Now, the Texas legislature, they do pass laws. They do pass statutes. What we see also at the federal level, the U.S. Congress also passes statutes. They create laws. Right? So we have these two different levels. You may recall this from federalism or from other classes, but in short, just note that we have two sources of statutory law. One's at the federal level and one's at the state level. Let's move on. So, administrative regulations, what are they? They are laws that govern the activities of administrative agencies of government. Okay, so government agency action can include rulemaking, adjudication, or the enforcement of a specific regulatory agenda. So remember that the legislature is tasked with passing laws or creating statutes, right? But it's up to the executive branch to implement those laws passed by the legislature. Well, we see the bureaucracy helping with that implementation through rulemaking or adjudication or enforcement of a specific regulation. Okay, this is what's referred to as administrative regulations. And administrative regulations derive from both national and state regulations code. Okay, so we have two sources here for administrative regulations: federal and state. Let's move on. So we have court precedents. All right, this is a principle or rule established in a previous legal case that is either binding on or persuasive for a court or other tribunal when deciding subsequent cases with familiar issues or facts. In other words, we can say it like this, okay? Precedents is a principle that basically says what was done in the past we will use for this case. What was done in the past about similar cases, about similar issues, we will use that standard, that decision in this case that is similar to the previous case. Okay? That's what we're talking about here. And this helps with deciding difficult cases. And you can imagine that this is kind of a shortcut, right? It helps with these difficult cases. Because we can just look at the previous case that dealt with similar issues, and we can just look at that to help us judge, or help judges judge in that particular case. Okay? So it does help with difficult, complex cases. Some cases are slam dunk, some cases are easy, other cases are not so much. And so this helps, court precedents helps with, and this principle helps with the getting through difficult cases. Let's move on. Another source of law comes from local ordinances. That is, a local ordinance that is a law for a political division smaller than a state or a nation. So in other words, municipalities, cities get to pass these ordinances. What are some examples of some ordinances, you may ask? Good question, by the way. Well, it could be pet ordinances that cities have issued regarding the regulation of pets, right? That it clearly establishes, you are responsible for caring for your pet. It could be noise level. There's a certain level of noise that if you violate that you are in violation of a city ordinance, which then you could be held responsible for. You could be held accountable for. And vehicle ordinances. For example, you may have seen some signs in cities that say no engine brake. Well, that's those cities have passed ordinances that ban 18-wheelers from using what's known as the engine brake. This engine brake, I have not heard it, but I've heard from others that it's extremely loud. Extremely loud. It's a braking mechanism for which large trucks, very large trucks, have to be able to stop. And using that device is extremely loud. Well, that violates noise levels, right? So some cities have actually banned that. Right? So that's some examples, okay, of some ordinances. And let's move on to the hierarchy of law. So constitutional law supersedes statutory law. Okay, that is to say that constitutional law is higher. It supersedes statutory laws passed by the legislature. Okay, statutory laws supersede that of administrative regulations. Okay, and administrative regulations supersedes local codes or ordinances. So we see this hierarchy, right? So at the very bottom of this hierarchy is in fact local codes or city ordinances, and at the very top we have constitutional. Right? So so we have this hierarchy. So what's interesting is when we see conflict, right? When we see a when we see a statutory law that counters that of constitutional law, well, constitutional law will supersede. It will override or overrule, if you will, what was said in that statutory law. And the same thing about statutory law versus administrative regulations. Okay. But I think we get this. This is a pretty easy point, right? That we have this hierarchy, and that the one above supersedes the rest. Okay. I'm digressing. Let's move on. So the types of jurisdiction. Well, we have original jurisdiction. So every court system has jurisdiction over certain cases. All right. We have original jurisdiction, appellate jurisdiction, and exclusive jurisdiction. So original jurisdiction, this is referring to the fact that the court gets to hear the case first. So, for example, municipal courts typically have original jurisdiction over traffic offenses that occur within the city limits. Okay, appellate jurisdiction is the power for a higher court to review lower court's decision. So, for example, the Texas Court of Criminal Appeals has appellate jurisdiction over district courts. Okay. And we have exclusive jurisdiction. This is to say that only that a court can hear a specific case. So, for example, only the Texas Court of Criminal Appeals can hear appeals for death penalty sentences. Okay, so that's what we're looking at here when we say jurisdiction. Right? We have original, appellate, and exclusive. Now, there is another type of jurisdiction. We don't really see that here in the state of Texas, but we do at the federal level. It's called discretionary jurisdiction. That is to say that the U.S. Supreme Court gets to decide what cases it will hear. It has full discretion over what cases it will hear. Versus here in Texas, like the Texas Court of Criminal Appeals, it must hear. If in all death penalty cases, and we'll talk about the death penalty in another lecture, but all death penalty cases, if someone is issued the death penalty, they have an automatic appeal to the Texas Court of Criminal Appeals. So they have to hear that case. Okay? So we have these three jurisdictions here in Texas. Let's move on because we still got more ground to cover. So you may recall from a previous lecture that we have what's known as a bifurcated court system. Okay, so we have the Texas Supreme Court and we have the Texas Court of Criminal Appeals, where the highest appellate court that you can appeal a civil case to is the Texas Supreme Court. Now, so the Texas Supreme Court hears all civil cases. The Texas Court of Criminal Appeals, they hear criminal cases, and that's all they hear. Okay, so if you're talking about a civil matter, the highest appellate court in the state of Texas you can appeal to is the Texas Supreme Court. If you're talking about a criminal case, the highest court you can appeal a criminal case to is in fact the Texas Court of Criminal Appeals. Okay, there's only 2 states within the United States that actually uses a bifurcated system, and that is Texas and Oklahoma. This is kind of an interesting thought. Let's move on. So civil cases, right? So what we've already defined this. We've already talked about it, but again, remember it's disputes between 2 or more individuals or organizations, right? So examples, again, divorce, child custody, contracts, protective orders, and evictions. And these are all examples of civil cases. Okay? So the basic steps in a civil case: we have the complaint, right? That is to say that we have a dispute that has been formed. Right? We have the summons summoning these individuals before the court. We have discovery of the evidence. What evidence do you have to support your dispute? We have the settlement, which deals with the what kind of relief are we looking for. We have the actual trial, and then potential appeal if the individual decides to appeal the original ruling of the case. Right. So that's what we're looking at for civil cases. For criminal justice, right, the Texas court system has 2 goals, and they're kind of at odds with one another. And here's what I mean. So the first goal is to protect the people, right? To protect victims, to protect the public at large. That's its goal. And its second goal, which kind of contradictory in a way, it may appear to be at least, is to protect the accused. Even if they are guilty, we have to protect those rights. Now, we've already kind of mentioned this when we talked about the Constitution, right? That criminal proceedings there are laws that are in place by the Constitution that protect those who are accused, for those who are going through criminal proceedings. Now, for those of us who say, that we're innocent and that only those who are wrongdoers should, the book should be thrown at them. While we may agree with that, we have to realize that their rights, they're still human. No matter what they've done, no matter how heinous that crime may be, they're still human. Now, we may not like them, right? But they're still human. So, for the simple fact they exist, again, their rights must be upheld. So we protect the people, protect the innocents, protect the victims, and yet at the same time, protect the accused. So these 2 goals seem almost at odds with one another. But I'm digressing. So the basic steps in a criminal case, we have the arrest. That is to say that they have been taken into custody. We have the indictment, the official reading of the charges against them. Typically, what we see is those who are arrested for for violating criminal law. We often see them going through this plea bargaining. In other words, okay, fine, you have me. You have good evidence. I don't think I'm going to win. So what's a good deal that I can get out of this? Right? That type of situation. That plea bargaining. We have the trial. That is to say that the evidence is argued, is presented by both sides, and that the court, whether it's a jury court or whether it's a we have the right, if we are going through a criminal proceeding, by the way, we have the right to a trial by jury or a trial by judge. The judge acts as judge and jury. So in this trial, right, we have the court issuing a decree of innocence or guilt, and then we have the post-trial. Again, that could be going back to the everyday life, or that could potentially mean imprisonment or other consequences for violating criminal law. So let's move on to the judicial selection process. Okay, the judicial selection varies substantially across the United States. There is no one way to do it across the United States. We have partisan elections. We have non-partisan elections. We have legislative elections and gubernatorial appointments. So what does all this mean? Let's break this down. So partisan elections, this is what we have here in Texas. That is to say that when judges decide to run to be a judge, they have to declare their party affiliation. They have to say, I'm running as a Democrat or I'm running as a Republican. And we elect them. Remember, here in Texas, we elect all our judges. So we elect them to that position. And they have to, it's mandatory that they have to declare their party affiliation. In non-partisan elections, some states have decided to have this way, that they do run for election. They are elected by the people, but they do not disclose, nor are they required to say, I'm a Democrat or I'm a Republican. They are considered non-partisan elections. So let me ask you, well, actually, let me save that question for here just for a second here. Then we have legislative elections. And that is to say that the legislature gets to appoint. Right? And we have gubernatorial appointment. That is to say that the governor of the state gets to appoint these judges. Of these four, which one sounds best to you? I'm curious to know what you think. All right, let's continue on. So there are some arguments for and against partisan elections. Okay, so let's talk about the arguments supporting partisan elections of our judges here in the great state of Texas. And when I say judges, I mean everyone. From the Texas Supreme Court, the Texas Court of Criminal Appeals, all the way down. We elect them. Right? So the argument supporting this form, this method of selection, right, is the most. They say that it's the most democratic. That is to say that it allows the people to have a direct voice in selecting their judges. And hey, this is extremely democratic. We the people get to elect them. We the people get to choose, right? So the power is in our hands, right? They are the debate. Those supporting partisan elections also say that voters are capable of selecting a judiciary that reflects their values, and that they are entitled to that choice. That we are able to decipher, we are able to discern what our judges think, and we have the absolute power, right, and authority, and entitled to select those judges, right? And the threat of being voted out of the office holds judges accountable. So listen, yes, they're partisan. Yes, they get to declare Democrat, Republican. Yes, but if they misbehave, if they've acted and behaved that's unbecoming, then you and I, we have the absolute right to hold them accountable, hold their feet to the fire, right? Now, that's to say, do we have all the information? Right? Because this may come as a surprise, but a judge's, what's it called? Oh man, the judicial record. The misconduct record is actually hidden from the public. We don't have access to it. So a judge that has a gambling problem might be judging in a gambling case, and that seems a little too much on the nose there, or maybe even a conflict of interest. But we, the public, we will never know that because that particular record is hidden. We don't have access to it. And getting access to it is nearly impossible. I'm digressing. So the question becomes, do we really have all the information that we need to be able to discern, to be able to judge? Pun intended. Let's move on. Well, the arguments against partisan elections, they would argue that the growing amount of fundraising in election campaigns gives special interest groups a foothold to manipulate the judiciary to their liking. Right? So this idea that since they are up for re-election, specifically partisan elections, that interest groups can get involved. Interest groups that have a lot of money. Now, that's not to say that all interest groups are bad. That's not to say that lobbyists are inherently evil. I'm not making that assertion at all. But what I am saying is they do have influence, right? And that influence can be used in a negative way, and it can be manipulated. It can be used in a manipulative way as well to guide or to put pressure on a judge who's elected, who's subjected to the elections process, who needs, i.e., who needs donations to their campaigns. They may be manipulated. Right? Other arguments center on the idea that highly polarized judiciary made up of judges who are pressured to please their campaign supporters. So think about it like this, right? Since judges are elected, we the people, while it's extremely democratic, we can put extreme pressure on our judges to behave or to rule in what may actually be illegal. And what I mean to say by that is this. A case that's being heard before a judge, if the right thing to do according to the law, right, is to do one way, but yet public opinion says, demand the other way, is that justice? Is that impartial, or are we influencing our judges? Now that could be you and I as individuals putting that pressure onto that judge, or that could be those who donate to their campaign, be it interest groups or otherwise. It could just be donors to their campaigns. They can put pressure. And do we want a judiciary system that our judges can feel external pressure to do something? I don't know. I have questions, right? And lastly, voters' knowledge of partisanship is limited. What do we actually know? What does the mass public know about partisanship? What is partisanship? Right? Do we know enough about that? If we don't, can we honestly make a good choice? Right? So what is partisanship? By the way, partisanship is, we're talking about the basically the amount of dogmatic loyalty to a political party, right? We're talking about holding that party line, regardless of what that line may be, whether we like it, whether we don't like it. Put that to a side. It's this idea that you are beholden to a political party, right? So yeah. So what do you think, right? So what do you think? We've looked at arguments supporting and arguments against. What do you think? What do you think about this? Where do you think? Should we elect our judges? Should they be appointed? Or do you? What do you? Yeah, man. I'm just sitting over here thinking, right? Should judges be elected? Maybe we do support that. Or maybe we think they should be appointed. Or maybe they should be elected, but not in partisan elections. I don't know. Let me know what you think. We are here at the conclusion of this lecture. If there's anything I've said or if there's anything that doesn't make any sense, please feel free to reach out to me and let me know. Until next time, peace.